Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Cerenade e-immigration. You're probably hearing a lot of buzz about how law firms are starting to use artificial intelligence. And while I recently had the opportunity to talk to the folks at Cerenade about their case management system, e-immigration, they've been making software for immigration attorneys longer than anyone else. And they're doing some pretty cool stuff with AI. They have a suite of tools that they're calling AI workmates. That sounds like it's got huge time-saving potential. One of their tools even lets you upload a PDF and instantly creates a client profile. There's another tool that can read content on the website and instantly summarize it, which is pretty helpful when referencing historical case rulings or, dare I say, country condition evidence. They've got some other tools too scheduled for release later this year. So if you're trying to wrap your head around how to use AI in your practice, I encourage you to have a chat with the folks at Cerenade. Also, check out their blog at cerenade.com/blog for their recent articles on AI in legal practices. Or, of course, click on the link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. We meet again for another week. Anything going on in immigration news unrelated to a Salvadoran gulag? Of course. Looks like the Supreme Court's going to decide whether district courts can enter nationwide relief in the citizenship executive order cases, and maybe in immigration generally. Commence the holding of breath. This week, the Supreme Court stepped in to temporarily stop some flights to said Salvadoran gulag, as we all argue what the Alien Enemies Act means. U.S. senators are going to El Salvador. Registration allegedly begins. A U.S. District Court judge is investigating sanctions against the Trump administration. TPS fights are heating up. The student visa actions are taken off. So much. It's hard to keep up. I'll do my best to do my part. This week, with these two cases. Our first case is Abrego Garcia v. Noem, published by the Fourth Circuit on April 17th, 2025. I have not been shy on this podcast and elsewhere about how I feel about the indefensible tragedy of Mr. Abrego Garcia, the clearly non-MS-13 guy who in any event has withholding of removal and who the administration labeled a terrorist because it wanted to and then shipped him off to a third country concentration camp. The country from which he had withholding of removal. It is a clear violation of immigration law intended by the administration to create a constitutional crisis where it believes it can garner the most sympathy for violating the law, if we're giving them credit for being intentional. I can't stop thinking about this. I know a lot of you can't either. The stakes couldn't be higher, and all the while, Mr. Abrego Garcia sits in a gang prison in the country from which he received withholding of removal. His attorneys keep winning, and yet he remains. Fortunately for us all in America, the federal judiciary is not backing down from the rule of law. A federal district judge in Maryland is doing all that a federal judge can do to make sure that the law is enforced on the executive. The executive is begging for sanctions and appealing everything they can. Let's be clear, DOJ is operating in bad faith, in a manner that embarrasses me as a lawyer, but also kind of shows what the world would look like if we lived in a world where people stopped listening to lawyers who took their oaths seriously. Anyway, on April 17th, a unanimous Fourth Circuit issued a banger affirming the district court's actions and denying DOJ's nonsense emergency stay and appeal for a writ of mandamus. It's authored by a Republican-appointed judge nonetheless, even though that doesn't matter and shouldn't matter. Everyone's talking about this decision, and it's not precedential, but this is a highly unusual case, and there aren't many decisions this week. The thing reads like one of those old important law school cases. And I mean that as a compliment. So you know what? I'm going to just read the whole thing. It's only 7 pages, double-spaced anyway, and I'll skip the citations. It's worth it, immigration nerds. If you've already read it yourself, of course, skip to the next case. Judge Wilkinson for the court. Quote, "The relief the government is requesting is both extraordinary and premature. While we fully respect the executive's robust assertion of its Article 2 powers, we shall not micromanage the efforts of a fine district judge attempting to implement the Supreme Court's recent decision. It is difficult in some cases to get to the very heart of the matter. But in this case, it is not hard at all. The government is asserting a right to stash away residents of this country in foreign prisons without the semblance of due process that is the foundation of our constitutional order. Further, it claims in essence that because it has rid itself of custody, that there is nothing that can be done. This should be shocking, not only to judges, but to the intuitive sense of liberty that Americans far removed from courthouses still hold dear. The government asserts that Abrego Garcia is a terrorist and a member of MS-13. Perhaps, but perhaps not. Regardless, he is still entitled to due process. If the government is confident of its position, it should be assured that position will prevail in proceedings to terminate the withholding of removal. Moreover, the government has conceded that Abrego Garcia was wrongfully or mistakenly deported. Why then should it not make what was wrong right? The Supreme Court's decision remains, as always, our guidepost. That decision rightly requires the lower federal court to give due regard for the deference owed to the executive branch in the conduct of foreign affairs. That would allow sensitive diplomatic negotiations to be removed from public view. It would recognize as well that the facilitation of Abrego Garcia's return leaves the executive branch with options in the execution to which the courts, in accordance with the Supreme Court's decision, should extend a genuine deference. That decision struck a balance that does not permit lower courts to leave Article 2 by the wayside. The Supreme Court's decision does not, however, allow the government to do essentially nothing. It requires the government to facilitate Abrego Garcia's release from custody in El Salvador and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. Facilitate is an active verb. It requires that steps be taken, as the Supreme Court has made perfectly clear. Plain and active meaning of the word cannot be diluted by its constriction, as the government would have it, to a narrow term of art. We are not bound in this context by a definition crafted by an administrative agency and contained in a mere policy directive. Thus, the government's argument that all it must do is remove any domestic barriers to Abrego Garcia's return is not well taken in light of the Supreme Court's command that the government facilitate Abrego Garcia's release from custody in El Salvador. Facilitation does not permit the admittedly erroneous deportation of an individual to the one country's prison that the withholding order forbids, and further, to do so in disregard of a court order that the government not only subtly spurns. Facilitation does not sanction the abrogation of habeas corpus through the transfer of custody to foreign detention centers in the manner attempted here. Allowing all this would facilitate foreign detention more than it would domestic return. It would reduce the rule of law to lawlessness and tarnish the very values for which Americans of diverse views and persuasions have always stood. The government is obviously frustrated and displeased with the rulings of the court. Let one thing be clear. Court rulings are not above criticism. Criticism keeps us on our toes and helps us to do a better job. Court rulings can overstep, and they can further intrude upon the prerogatives of other branches. Courts thus speak with the knowledge of their imperfections, but also with a sense that they instill a fidelity to the law that would be sorely missed in their absence. Quoting the Federalist Papers, energy in the executive is much to be respected. It can rescue government from its lassitude and recalibrate imbalances too long left unexamined. The knowledge that executive energy is a perishable quality understandably breeds impatience with the courts. Courts, in turn, are frequently attuned to caution and are often uneasy with the executive branch's breakneck pace. And the differences do not end there. The executive is inherently focused upon ends, the judiciary much more so upon means. Ends are bestowed on the executive by electoral outcomes. Means are entrusted to all of government, but most especially to the judiciary by the Constitution itself. The executive possesses enormous powers to prosecute and to deport, but with powers come restraints. If today the executive claims the right to deport without due process and in disregard of court orders, what assurance will there be tomorrow that it will not deport American citizens and then disclaim responsibility to bring them home? And what assurance shall there be that the executive will not train its broad discretionary powers upon its political enemies? The threat, even if not the actuality, would always be present, and the executive's obligation to take care that the laws be faithfully executed would lose its meaning. Today, both the United States and the Salvadoran governments disclaim any authority and/or responsibility to return Abrego Garcia. We are told that neither government has the power to act. The result will be to leave matters generally and Abrego Garcia specifically in an interminable limbo, without recourse to law of any sort. The basic differences between the branches mandate a serious effort at mutual respect. The respect that courts must accord the executive must be reciprocated by the executive's respect for the courts. Too often today that has not been the case, as calls for impeachment of judges for decisions the executive disfavors and exhortations to disregard court orders sadly illustrate. It is in this atmosphere that we are reminded of President Eisenhower's sage example. Putting his personal opinions aside, President Eisenhower honored his inescapable duty to enforce the Supreme Court's decision in Brown v. Board of Education to desegregate schools with all deliberate speed. This great man expressed his unflagging belief that the very basis of our individual rights and freedoms is the certainty that the president and the executive branch of government will support and ensure the carrying out of decisions of the federal courts. Indeed, in our late executive's own words, unless the president did so, anarchy would result. Now the branches come too close to grinding irrevocably against one another in a conflict that promises to diminish both. This is a losing proposition all around. The judiciary will lose much from the constant intimations of its illegitimacy, to which, by dint of custom and detachment, we can only sparingly reply. The executive will lose much from a public perception of its lawlessness and all of its attendant contagions. The executive may succeed for a time in weakening the courts, but over time history will script the tragic gap between what was and all that might have been, and law in time will sign its epitaph. It is, as we have noted, all too possible to see in this case an incipient crisis. But it may present an opportunity as well. We yet cling to the hope that it is not naive to believe our good brethren in the executive branch perceive the rule of law as vital to the American ethos. This case presents their unique chance to vindicate that value and to summon the best that is within us while there is still time. In sum, and for the reasons foregoing, we deny the motion for the stay pending appeal and the writ of mandamus in this case. It is so ordered. End quote. And that is Abrego Garcia v. Noem. Are you fighting like a maniac, completely overwhelmed by the chaos of the new administration? Immigration policies are shifting fast, the pressure is piling up, and clients are desperate for help. You're working around the clock, but there's only one of you. Well, Staffy's got your back. Staffy's bilingual virtual paralegals and administrative assistants handle USCIS forms, client intake, evidence gathering, and scheduling, so you're not drowning in paperwork while trying to fight for your clients at the same time. Stop running on empty. Staffy gets you a trained, ready-to-go team fast with HR-backed support, onboarding, and continuous training. You don't have time to do it all alone, and you don't have to. Schedule a consultation at staffy.cc, that's stafi.cc, and claim $500 off your first month. Elevate your advocacy and storytelling skills at the annual Immigration Court Trial College in Kansas City. Get ready for a transformative experience at the annual Immigration Court Trial Advocacy College, now hosted by the Pen and Sword, formerly the clinic at Sharma Crawford Attorneys at Law. That's friends of the pod and friends of the Kevin, Rekha and Michael Sharma Crawford, excellent immigration attorneys. The college convenes from April 24th to 26th and will focus on detentions, bonds, and release for 3 action-packed days of hands-on practical training and expert insights. This is not your average Talking Heads program. This is real cases, real witnesses, and real courtrooms designed to give you a real edge in your immigration practice. Put another way, this isn't just another training. It's an opportunity to transform your practice and fight for justice in a way that matters. Sharpen your skills, amplify your voice, defend immigrant rights like never before. Don't miss out, because space is limited. Check out all of the links to Rekha and Michael Sharma Crawford, their firm, and the Pen and Sword in the show notes. And if you want to get a bit of a discount for the Trial Advocacy College, click on the link in the show notes or use promo code IMREVIEW2025, that's IMMREVIEW2025. Keep up and join the good fight. Well then, our last case is Abrego v. USCIS, published by the 6th Circuit on April 16th, 2025. So remember Mr. Mathen's saga from 2 weeks ago? This is a similar issue. Good thing the 11th Circuit hadn't issued this ruling before Mr. Mathen's case. Not a good one for non-citizens from a split 6th Circuit. Mr. Abu is from some not-named country and is a lawful permanent resident. In 2017, he pled guilty in Kentucky State Court to facilitating theft by deception and fraudulent use of a credit card. Seems like he hadn't been in LPR for that long because DHS initiated removal proceedings claiming that he had been convicted of a CIMT committed within 5 years of adjusting. And you know what? I'm willing to bet that facilitating theft in Kentucky means a lot more than simply providing an airplane. But I digress. After that, Mr. Abu applied to naturalize. That is, with removal proceedings pending. So to be honest, it's pretty distinguishable from Mr. Mathen's case right out the bat, procedurally and factually for that matter. Because when Mr. Mathen applied to naturalize and had that naturalization application denied, twice, he was not in removal proceedings yet. Mr. Abu is. USCIS gave him his naturalization interview, but then took no action, which to be honest seems to me what they have to do under the statute. The Attorney General, which is USCIS for these purposes under the statute, cannot naturalize someone while removal proceedings remain ongoing. That's a paraphrasing of INA Section 318. At the same time, INA Section 336B requires USCIS to decide naturalization applications 120 days maximum after their interview, hence setting up a statutory showdown, which is often how these type of cases develop, the opposite of Mr. Mathen's. Removal proceedings are ongoing before USCIS makes a decision on the naturalization application, resulting in USCIS not making any decision, resulting in a 336B lawsuit asking a federal judge to decide the matter his or herself. Here, like in most type of cases like this, the non-citizen is asking the district court judge to issue declaratory relief, confirming his prima facie eligibility for naturalization, which the naturalization statutes allow if USCIS takes over 120 days post-interview to make the decision. But we've got that problem. Does Section 318 prevent the district court judge from doing that, at least where here removal proceedings are pending before USCIS even issues their naturalization decision? It does, says the Sixth Circuit majority. Call. The statute prevents the Attorney General from deciding a naturalization application where removal proceedings are ongoing. Pursuant to a warrant of arrest, if I'm not mistaken, though. We'll return to that in a sec. But how can that mean the district court? The statute is focused on preventing the Attorney General from deciding a naturalization application? Well, the Sixth Circuit first explains, quote, "We must interpret different sections of the Immigration Code as a harmonious whole," end quote. To me, this really does seem to come down to Section 336B. That section wasn't applicable in Mr. Mathen's case, but it very much is here. Here, Mr. Abu is, again, exercising his right to sue under Section 336B, which permits federal district court suit where USCIS takes over 120 days to decide. But per the statute, explained the Sixth Circuit, USCIS had to take over 120 days to decide the application here because the removal proceedings were pending. So if after 120 days, Mr. Abu can just sue in federal court to get a federal district court judge to determine his naturalization eligibility, notwithstanding the pending removal proceedings, it kind of makes Section 318 meaningless. Quote, "The text and context of Sections 318 and 336B thus suggest that Congress intended for removal to take priority over naturalization, regardless of forum," end quote. Again, factually, this is a bit distinguishable from Mr. Mathen's case, whose lawsuit traveled under INA Section 310C. One would think the logic being used here would not apply to that. In cases like this, when it comes to the 120-day delay type action, and after discussing the legislative history a bit, the Sixth Circuit explains that, quote, "Congress enacted Section 318 to end the race between removal and naturalization and explicitly prioritized removal over naturalization," end quote. Going a bit broader than I'd like, though, the court states, quote, "While Mr. Abu's removal proceedings are pending, no adjudicator, judicial or administrative, may determine his naturalization eligibility," end quote. But that said, if you've got a Section 310C naturalization application, that is, USCIS has already made the decision at least, and USCIS then NTAs your client, plow full speed ahead in the Sixth Circuit. Broad language aside, I think there's a strong argument that this decision should not preclude de novo review in such circumstances. To the Sixth Circuit, though, returning to this case, that Section 318 doesn't mention district courts doesn't change the court's mind, given the legislative history of all of this and the clear intent of the statutory framework. In so holding, and using some broad language to boot that I'm sure Oyl will also use to argue applies to Section 310C actions, the Sixth Circuit enters a circuit split, primarily against the Ninth Circuit. No mention of the Seventh Circuit or that whole thing about how Section 318 also has that, quote, "pursuant to a warrant of arrest," end quote, language, discussed in Mr. Mathen's case 2 weeks ago. I wonder why not. As to Mr. Abu, though, it means he's not getting his naturalization application decided unless and until he wins in immigration court, even though he's really only asking for declaratory relief. To the Sixth Circuit, the declaration of, say, prima facie naturalization eligibility, quote, would be an unenforceable advisory opinion, end quote. And there I think the Sixth Circuit really is splitting from its neighbor circuit, the Seventh. Indeed it is, and the Third Circuit, finally cited in this decision, and so here's the gong again. Although perhaps not even gong-worthy, still used it though. The Sixth Circuit distinguishes the Third and Seventh Circuit cases by stating, quote, "These cases involved the propriety of a declaratory judgment where the district courts exercised jurisdiction under an entirely different provision, Section 310C," end quote. So maybe this all doesn't apply to Section 310C. On the other hand, the Sixth Circuit has apparently addressed the Section 310C naturalization lawsuit issue during removal proceedings before in Zayed v. United States from 2004. And held, it seems, that Section 336B would indeed preclude a Section 310C action in all respects, except for permitting a district court to review whether, indeed, in that circumstance, the naturalization applicant was in removal proceedings. I haven't read Zayed, and I don't know how that holding is possibly correct, and the Sixth Circuit doesn't actually defend it in this decision, but precedent is precedent if that is what the court said 21 years ago. Rough stuff. And a quite confusing case, no? Now imagine having to additionally convert all of the 8 USC citations into INA provisions so listeners like you didn't get double confused. Hypothetically. Anyway, Mr. Abu lost, and things are not great for naturalization seekers in the Sixth Circuit, it seems. Judge Gibbons issued a dissent longer than the majority decision, believing that Section 336B's use of the word, quote, Attorney General, end quote, means only USCIS and not the district courts. Judge Gibbons also reads the legislative history differently and additionally believes that Mr. Abu would be eligible for declaratory relief. Concluding that, quote, the importance of this case cannot be overstated, end quote, Judge Gibbons would permit a federal district court to determine Mr. Abu's naturalization eligibility. But alas, not to be. And that is Abu v. USCIS. So there you have it. You're all caught up with past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to, from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.